Hello friends, in the series on the income tax cases, today we will discuss the issue that if any legislation is brought by the government into the Income Tax Act, any provision is introduced or any explanation is introduced, then whether the assessee can challenge this provision or the explanation in a writ court, and what is the methodology or what is the law established in this regard, that how the courts takes this challenge of the legislation or changes in the Income Tax Act by the assessee. This issue has been taken by Calcutta High Court in the case of IFGL, Refractories Limited and another versus Union of India and others. This case has been reported in 463 ITR at page number 649 and the date of the judgment is 3rd October 2023. In the present case, the assessee challenged the explanation added to section 10AA subsection 1, which was introduced with effect from 1st April 2018, and that explanation was regarding that the deduction under section 10AA will be allowed from the total income of the assessee before giving effect to section 10AA, and the deduction under section 10AA will not exceed the total income of the assessee. This was the explanation which was added to section 10AA subsection 1. The assessee challenged this explanation that it is ultra vires into the Calcutta High Court. When the Calcutta High Court heard this matter, the Calcutta High Court said that it is a settled law that the courts keep themselves restrained from striking down any provision of any act until and unless that provision is manifestly unjust or glaringly unconstitutional. The court said that in the present case, the explanation to section 10AA subsection 1 has been added just to clarify the main provision. The court said that the purpose of explanation is to explain the meaning and indentment of the act itself. The court said that the purpose of the explanation is to clarify and to make it consistent with the main provision. The court also said that it provides the additional support to the main provision, and it is a settled law that the explanation cannot interfere and change the enactment. And the court also said that the explanation which is added to a provision cannot take away the statutory right. The Calcutta High Court said that the assessee does not have any vested right to claim the exemption, and before claiming the exemption, the assessee has to satisfy the conditions. In the present case, the court said that on the pursual of the explanation to subsection 1 of section 10AA, that explanation did not validate any invalid law and does not impose any new tax illegally or otherwise. The court said that in the present case, the explanation didn't impose any new method of computation but only clarified the main provision of section 10AA subsection 1. The court said that the legitimate expectation of the society cannot take the power from the legislatures to make the enactment, and the courts are very slow in striking down the provisions because they do not want to interfere into the powers of the legislature. Friends, this case is very important as far as challenging the various provisions of any act as far as the constitutionality of their of the provisions is concerned, because the courts generally do not interfere in enactment of the law. They just interpret the law and they stuck down only in the cases when they are manifestly unjust or some glaring unconstitutional element is there. So in the present case, the court said that the explanation added to section 10AA subsection 1 is not violative of article 19, that is protection of certain rights regarding freedom, etc. Article 14 that talks about equality, and article 265 of the Constitution of India that says that no tax can be collected or imposed without the authority of law. At the end of this video, once again I am repeating the name of the case. The name of the case is IFGL Refractories Limited and another versus Union of India and others, and this case has been reported in 463 ITR at page number 649. The matter has been decided by Calcutta High Court and the date of the judgment is 3rd October 2023. Thank you, friends.